Hello, I'm Taniya Pandey and I welcome you to this week's episode of Courts This Week on LiveLaw. Let's look at the significant legal developments of the week gone by. The Supreme Court on 5th March granted interim protection from arrest to Amazon Prime Video's India head Aparna Purohit in the FIR registered by UP police over alleged hurting of religious sentiments by the web series Tandav. The bench of Justices Ashok Bhushan and R. Subhash Reddy observed that the protection from arrest will be subject to the petitioner cooperating with the investigation and appearing before the police as and when summoned. The bench also expressed dissatisfaction about the new rules framed by the union to regulate OTT platforms. Justice Bhushan told the Solicitor General that the new rules lack teeth as there is no provision for prosecution or fine. Without a legislation, there cannot be effective control, Justice Bhushan remarked. The Supreme Court has held that declaration of moratorium under Section 14 of the Insolvency and Bankruptcy Code covers criminal proceedings for dishonor of check under Section 138 of the Negotiable Instruments Act against the corporate debtor. A bench of Justices R.F. Nariman, Naveen Sinha and K.M. Joseph delivered the judgment on a batch of petitions which challenged the continuation of criminal trial under Section 138 of the Negotiable Instruments Act during the pendency of liquidation proceedings in the National Company Law Tribunal. Some significant observations from the judgment were that the sweep of Section 14 IBC is very wide, explanation of the objective of the moratorium, and that Section 138 proceedings are really a hybrid provision to enforce payment under a bounce check if it is otherwise enforceable in civil law. The court also made an interesting comment that Section 138 proceedings can be called a civil sheep in a criminal wolf's clothing, as they are quasi-criminal in nature. The Supreme Court has held that a petition either under Section 7 or Section 9 of the Insolvency and Bankruptcy Code is an independent proceeding which is unaffected by winding up proceedings that may be filed against the same company. The bench of Justices R.F. Nariman and B.R. Gavai observed that a secured creditor stands outside the winding up and can realize its security dehors winding up proceedings. Whether the day of remand is to be included or excluded for considering a claim for default bail, the Supreme Court has referred this issue to a larger bench. The court was considering the appeal filed against the Bombay High Court judgment, which held that the day of remand has to be included for the purpose of computing the period of 90 days or 60 days as contemplated in Section 167, subsection 2, Clause A, subclause 2 of the Code of Criminal Procedure. The Supreme Court has observed that a High Court, invoking its powers under Article 226 of the Constitution of India, can quash an FIR if the same is found to be an abuse of the process of law. In this case, a writ petition preferred by the accused for quashing the FIR registered under Sections 420 and 406 of the Indian Penal Code against them was dismissed by the Allahabad High Court. The accused's contention was that the FIR against him is a counterblast to the check bounce complaint filed against the complainant. While allowing the appeal, the bench of Justices D.Y. Chandrachud and M.R. Shah observed that the inherent jurisdiction under Section 482 CRPC and or Article 226 of the Constitution is designed to achieve a salutary purpose that criminal proceedings ought not to be permitted to degenerate into a weapon of harassment. The Supreme Court has observed that a contract is void if prohibited by a statute under a penalty, even without express declaration that the contract is void. The issue considered by the court in this case was whether the transaction entered into in contravention of Section 31 of the Foreign Exchange Regulation Act 1973 is void or is only voidable, and at whose instance can it be voided. Section 31 imposes a condition that a person who is not a citizen of India is not competent to dispose of by sale or gift, as in this case, any immovable property situated in India without previous general or special permission of the Reserve Bank of India. The bench of Justices A.M. Khanvilkar, Indu Malhotra and Ajay Rastogi observed that the condition predicated in Section 31 of the FERA Act is mandatory. Settling an important issue in the income tax law, the Supreme Court on March 2nd held that the amounts paid by Indian companies for the use of softwares developed by foreign companies do not amount to royalty, and that such payments do not give rise to income which is taxable in India. Therefore, there is no liability for Indian companies to deduct tax at source with respect to purchase of softwares from foreign companies. The bench was hearing a batch of over 86 appeals which challenged the decisions of various high courts, holding that consideration paid for purchase of foreign software amounts to royalty. The Supreme Court has observed that false explanation or non-explanation of the accused to the questions posed by the court under Section 313 of the Code of Criminal Procedure cannot be used as a link to complete the chain. In this case, the accused was convicted by the trial court for the murder of his wife. Later, the Bombay High Court upheld the conviction. In appeal before the Apex Court, the accused contended that the case rests entirely on the circumstantial evidence and that the prosecution had not been in a position to establish that the death of the deceased was homicidal. Taking note of the evidence on record, the bench observed that there were no marks on the body of the deceased, and the post-mortem report showed that the cause of the death was asphyxia due to hanging, and the prosecution couldn't prove that the death was a homicide. The court also observed that Section 106 of the Evidence Act does not directly operate against either the husband or the wife staying under the same roof and being the last person seen with the deceased. The period of limitation for filing the petition under Section 34 of the Arbitration and Conciliation Act would commence from the date on which the signed copy of the award was made available to the parties, the Supreme Court has held. The bench comprising Justices Indu Malhotra and Ajay Rastogi observed that there can be no finality of the award except after it has been signed. The Supreme Court has quashed an FIR alleging rape, observing that there is no allegation to the effect that the promise to marry given by the accused was false at the inception. The accused, whose petition seeking quashing of FIR was dismissed by the Allahabad High Court, had approached the Apex Court, contending that a bare reading of the FIR as well as the statement under Section 164 of CRPC would indicate that there was absolutely no intent on his part when he entered upon into the relationship not to marry the prosecutrix, nor can it even be suggested that the promise to marry was false. While allowing the appeal, the bench observed that in this case, the relationship was of a consensual nature, and there was only a subsequent refusal on the part of the accused to marry the prosecutrix, which gave rise to the registration of the FIR. Application under Order 9, Rule 13 of the Code of Civil Procedure cannot be automatically granted and can be allowed only when sufficient cause is made out to set aside the ex parte decree, the Supreme Court has observed. In this case, the tenant had filed an application to set aside an ex parte decree against him, which was dismissed by the trial court on the ground that no deposit was made by the tenant as required by Section 17 of the Provincial Small Cause Courts Act 1887, along with the said application. The High Court remanded the matter back to the trial court for reconsideration of the tenant's application under Order 9, Rule 13 CPC and Section 5 of the Limitation Act in accordance with law. In appeal against the High Court order, the bench comprising Justices Ashok Bhushan and R. Subhash Reddy noted that the tenant had not made out any sufficient ground to allow the applications under Order 9, Rule 13, and the High Court committed error in interfering with the order of the trial court. It is not seditious to have views different from the government. The Supreme Court observed while dismissing a PIL seeking action against former Chief Minister of Jammu and Kashmir, Farooq Abdullah, for his comments on abrogation of Article 370 of the Constitution. The plea filed by Rajat Sharma and Dr. Neil Srivastava alleged that Abdullah made a live statement that for restoration of Article 370, he would take help from China. They further alleged that the former CM is trying to hand over Kashmir to China and thus he should be prosecuted for sedition under Section 124A of IPC. The bench also imposed a fine of Rs 50,000 on the petitioners for making such claims. The Supreme Court has observed that the evidence of an interested person can be considered provided such evidence is corroborated by other evidence on record. The bench of Justices Ashok Bhushan and R. Subhash Reddy has observed that a close relative who is a natural witness cannot be regarded as interested witness. In this case, the accused was concurrently convicted in a murder case. Before the Apex Court in Appeal, the accused contended that two witnesses in this case are brother and mother of the deceased and thus are interested witnesses, and the conviction is based on the testimony of those interested witnesses. The bench referred to the decision in Ramchandar v. State of Haryana, in which it was observed that there is no proposition in law that relatives are to be treated as untruthful witnesses. Taking note of the other evidence on record, the bench found that prosecution had proven the guilt of the accused beyond reasonable doubt by leading cogent evidence. The Supreme Court read down Section 12(2)(c) of the Maharashtra Zilla Parishads and Panchayat Samitis Act 1961, which provides reservation of 27% of seats in the Zilla Parishad and Panchayat Samitis. Reservation in favor of OBCs in the concerned local bodies can be notified to the extent that it does not exceed aggregate 50% of the total seats reserved in favor of SC, ST and OBCs taken together. The bench of Justices A.M. Khanvilkar, Indu Malhotra and Ajay Rastogi observed. The court also observed that the rigid interpretation of the provision would be violative of the 2010 dictum laid down by the Constitution Bench in K. Krishnamurthy v. Union of India. The Supreme Court has observed that a dying declaration cannot be disbelieved merely because parents and relatives of the deceased were present in the hospital while recording it. In the declaration recorded by the judicial magistrate, the deceased stated that the accused had poured kerosene oil and set her ablaze. Challenging the concurrent conviction, the accused before the Apex Court contended that the dying declaration was tutored at the instance of family members of the deceased who were in the hospital at the relevant time. Examining the case records, the bench noted that the magistrate in her deposition had clearly stated that the relatives of the deceased were not there at the time of recording the dying declaration of the deceased. Dismissing the appeal, the court noted that if the dying declaration is considered along with the depositions of the other witnesses, it clearly establishes the guilt of the accused beyond reasonable doubt. In a significant judgment, the Himachal Pradesh High Court on 4th March observed that a surrogate woman getting child through arrangement by surrogate parents is entitled to avail maternity leave benefits under Rule 43(1) of the CCS Leave Rules 1972. The court also opined that it would be an insult to womanhood to distinguish between a mother who begets a child through surrogacy and a natural mother who gives birth to a child. The observation came from a division bench comprising of Justice Tarlok Singh Chauhan and Justice Sandeep Sharma, while considering a petition filed by a surrogate mother seeking maternity leave benefits. That's all for this week. We'll meet again very soon with more updates. I am Taniya Pandey, and I hope you have a wonderful day. Goodbye.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.